Hello, everyone, and a very warm welcome to you all. This is the expert workshop on the right to a nationality, equality in nationality rights in law and in practice. And this is an expert workshop of the Human Rights Council. I particularly welcome our participants and our distinguished panelists today. My name is Simon Walker. I'm the Chief of the Rule of Law and Democracy section at the Office of the High Commissioner for Human Rights here in Geneva. I'll be moderating the first panel of today's expert workshop. But before we begin, I have great pleasure to give the floor for opening remarks to Ms. Ruven Minnick-de Vella, and she is the Assistant High Commissioner for Protection at the Office of the United Nations High Commissioner for Refugees. Madam, you have the floor. We appear to have a technical problem, but we will be with you just in a short moment.
Dear colleagues, sorry, there is a hello, colleagues. This is Cecile from UNHCR. Sorry, there is a bit of issue of connection, but the HCP is connecting soon.
Thank you. We're here, and we're waiting. Okay, Ms. Minnick-de Vella, we can see you. I hope that the technical problem is now sorted and you have the floor. A very warm welcome to you.
Thank you very much. Can you hear me?
Very well, yes, thank you.
Oh, excellent. Sorry, I never thought I'd have connected issues in Geneva, but unfortunately, that appears to have been the case. My apologies for having kept all of you waiting, but a very warm welcome to this experts group workshop on promoting equal nationality rights in law and practice. As you all know, this is in fact a very logical sequence to the Human Rights Council Resolution 53/16, which calls on all states to adopt or implement laws consistent with the international obligations to address or to reduce statelessness, including through the elimination of all forms of discrimination. And of course, all of you know this way better than I, because many of you are practitioners in this, but just to say that discrimination in nationality laws and in the implementation is possibly one of the most egregious and complex issues that we confront today, Over 75% of all known stateless populations, as you know, probably belong to minority groups, whether they're nomadic groups, hill tribes, communities that have lived for generations on a territory without ever having been accepted as part of the society, or descendants of migrants who immigrated to those countries several generations ago. But what is incredibly also more complex is when member states actually formally codify discrimination or exclusion in their laws and policies. We have some 24 countries that have laws permitting the denial or revocation of nationality based on racial or ethnic grounds. We have 24 countries that don't permit women to confer nationality on their children. We have, mass deprivation of nationality still happening even in this last few decades. But more frequently, I think systemic discrimination actually happens much more in the context of administrative processes and informal practices, which have a direct and disproportionate impact on specific populations as well. And these forms of discrimination have far-reaching consequences. As we all know, many of these populations are prevented or have limited access to basic, including life-saving services such as medical attention, healthcare, education, freedom of movement, access to legal employment. And in its most egregious forms, discrimination can lead to persecution and forced displacement. And the 1 million Rohingya refugees in Bangladesh, I think, are possibly one of the most compelling illustrations of exactly what happens when a whole race of people are systematically and systemically discriminated against. Resolution 53/16 actually specifically calls on all member states to ensure that minority groups do have access to an effective nationality. And I know this will be part of the crux of your discussions in this workshop today as well. All that being said, though, it's not all gloom and doom. We do have the I Belong campaign, the 10-year I Belong campaign initiated by UNHCR, but which gathered so many partners, which concluded last year, the results of which were that over 560,000 people, stateless people, did obtain nationality. I was myself in Turkmenistan, in Central Asia, actually late last year, attended a regional conference on statelessness in Turkmenistan, where I did have the occasion to congratulate both Turkmenistan and Kyrgyzstan for having eradicated all known cases of statelessness on their respective territories. And I think that's an amazing example for other countries with similar situations to follow as well. But we also have some 20 plus countries that adopted laws to better protect stateless persons. We have 13 member states that adopted laws to prevent statelessness. And we even have 3 member states that removed gender discriminatory provisions from their nationality laws. And I think these are really hugely positive examples, and really an illustration of what can happen when there is political will and an intention to change things. But we should also not neglect some of the very significant regional developments as well, including the adoption of the Protocol on Statelessness to the African Charter on Peoples and Human Rights, which I think was certainly one of the most significant developments in terms of addressing statelessness in the African region. But all that being said, however, it's also true that we still have challenges despite some of these positive developments. And that is one of the reasons why we launched a global alliance to end statelessness last year. Many people ask, what's the difference between that and the I Belong campaign? The I Belong campaign was essentially initiated and led by UNHCR. The Global Alliance to End Statelessness is exactly that. It's an alliance. It is not led by UNHCR. It's led by a whole cluster of 8 entities, civil society, member states, NGOs, including the stateless organizations led by stateless persons themselves. And I think that's really been an essential difference. And we hope will be a catalyst, that this alliance will be really the catalyst to scale up solutions for statelessness across the world today. So with all of that, again, still fairly significant challenges that are there, the rise of ethno-nationalism, the deprivation of nationality as a measure to combat terrorism. This is all happening in the name of law and order, but some of these things are incredibly egregious. And we should not really allow them to pass unnoticed, and they definitely require our collective attention as well. All that being said, I would like to really just say that, again, my really warmest thanks to all of you for attending this workshop, but especially, of course, the panelists who are giving up their time to share their experiences, transferable positive examples, transferable practices, but also perhaps lessons learned, what we should avoid doing from having implemented certain practices, what we should avoid doing in the future as well, how to address obstacles and, or rather to overcome them, and how to scale up solutions as well. So with that, I really don't want to keep you waiting much further because I know I've delayed you considerably already, but also just to conclude by thanking OHCHR very specifically as our co-organizer, but also as one of our closest allies in this domain of statelessness, but also in many other domains as well. And I'm not just saying that because the High Commissioner for Human Rights happens to be a former UNHCR eminence grise, but because we do have this very, very close affinity and natural collaboration and partnership with you. So with that, I'll thank all of you for attending this and wish you all every success in your discussions. Thank you very much.
Well, thank you very much, Ms. Menik-Divella, also for your kind words. And I would like to echo, of course, the importance that we place in the cooperation with UNHCR as well on this issue, and of course on many other issues as well globally. So we will move to panel one. Before I do so, I just have a few housekeeping issues I would like to remind everyone of. First of all, please note that due to the ongoing liquidity crisis at the United Nations, this online meeting will be held solely in English without any interpretation. Second, following this meeting and pursuant to Human Rights Council Resolution 53/16, the United Nations High Commissioner for Human Rights, in coordination with UNHCR, will prepare a summary report on today's workshop. This meeting will be recorded and transcribed to support the drafting of this report, and the recording will also be made available on the webpage for the workshop. The third issue is today's panel discussion will commence with interventions from our four distinguished panelists. All other participants are requested to ensure that their microphones are muted while panelists are delivering their presentations. Each panelist will have a maximum of 15 minutes to deliver an intervention, and this will be followed by questions and answers and discussions, we hope, for around 20 minutes, which will be open, of course, to all participants. So with those housekeeping issues clear, I'm very happy to move on to the first panel, and this is an overview of discrimination in nationality matters. And this panel will, of course, highlight discrimination in nationality and highlight the disproportionate impact such discrimination has on, in particular, minorities, women, and children. Please note that if you would like to learn more about our panelists, their full bios can be found on the workshop website. And so I will introduce them briefly so we have as much time as possible. With that, let us move on to our first panelist, and I have great pleasure in welcoming Mr. Juan Sebastian Chamorro, who is a political activist and politician from Nicaragua. He was also a presidential candidate in 2021 before being imprisoned, exiled, and stripped of his nationality. Mr. Chamorro joins us today to share his lived experience. Mr. Chamorro, you have the floor.
Thank you very much. You can hear me well, right?
Very well, yes, thank you.
Thanks to the Office of the High Commissioner for inviting me to this workshop. Although I not consider myself an expert, I was arbitrarily stripped of my nationality, so I think I can speak from a personal perspective that complements the view of the experts. Nationality is what associates us with a common history, with tradition, with language, with land. It cannot be taken away from us because it's not something that we have. It is the very social essence of what we are. Despite the multiple origins of statelessness, I will focus on the one that affected me: arbitrary deprivation of nationality based on political grounds. This action is the result of an explicit policy by the state supposed to provide protection, to arbitrarily eliminate the link just because of my political opposition to the regime of Daniel Ortega in Nicaragua. Although mine is a very special case of deprivation of nationality, general conclusions can be derived from my experience as it develops identical consequences for others deprived of their nationality. The origins of statelessness conditions may differ, but the effects are basically the same. On February 9, 2023, the regime of Daniel Ortega of Nicaragua stripped me of my nationality. The very same day, they banished me and 221 other political prisoners from our homeland. After spending nearly 2 years in prison, we were told that we were free. Yet at that moment, we were also told that we were no longer Nicaraguans. This cruel paradox was the regime's final blow, a symbolic act meant to crush our spirit, even as we step into physical freedom. They wanted our first breath of liberation to be laced with pain. This was not just a political decision, it was deeply personal. The intention of the regime was for us to feel erased, cut off from our roots, our history, our identity. They wanted us to feel that a part of us was amputated that day. And the message was clear. Repression in Nicaragua does not end when you walk out of a prison gate. It follows you, shadows you, and reminds you, no matter where you are, that you are being marked. The arbitrary deprivation of my nationality was just the latest chapter of a long, brutal story of violence. In April of 2018, the Ortega regime reformed Social Security and massive protests erupted throughout the country. Ortega responded with live ammunition, killing more than 350 protesters, injuring tens of thousands, and imprisoning more than 1,000 political prisoners. After participating in a failed dialogue organized by the Catholic Church with the regime, I became a target. For 8 months, I lived under constant siege, illegal house arrest, and police harassment. After I announced my intention to run for president, the regime came for me with full force. On June 8, 2021, I was arrested without a legal warrant and held incommunicado for the first 89 days. I was accused for treason to the homelands and sentenced to 13 years in prison. The sentence broke my wife, my daughter, my family, because they believed they wouldn't see me until 2038. Prison was a living nightmare, and yet when the gates opened throughout a negotiation with the United States, and I thought that the worst was over, the regime delivered its final punishment. I was being banished from Nicaragua, and the regime declared me stateless. By the time of my release, the regime had already violated 19 out of the 30 articles of the Universal Declaration of Human Rights. And they weren't done yet. After our expulsion, all 222 of us had our homes, bank accounts, businesses, savings, and Social Security rights confiscated, lifetimes of efforts, entire legacies stolen in broad daylight. In the last 2 years, the Ortega regime has continued with stripping nationality. Hundreds, probably thousands of Nicaraguans traveling abroad have been not permitted to re-enter into the homeland, making them a de facto stateless. From arbitrary deprivation of nationality on political grounds derives the violations of all the fundamental rights given by citizenship, with the aggravating condition of state repression, persecution, and violence. It is not a passive condition of the state denial, but a consistent, deliberate action of repressive regime to not just eliminate any kind of legal bond, but to attack and infringe the most brutal suffering to the individual. Arbitrary deprivation of nationality is used in the general context of political repression and discrimination to legally eliminate any person who politically opposes a repressive regime. Arbitrary deprivation of nationality conveys a series of logistical, economic, social, and emotional complications that extend over time and space. It is a type of crime that the victim carries wherever he or she goes. I want to focus on a specific and deeply dehumanizing cruelty, the personal, devastating consequences of being declared stateless. Statelessness is not just a bureaucratic condition, it's a form of living torture. Without nationality, we are naked before the world. We have no protection, no right. The regime has deleted not only us from the citizen registry, but from our families' lives. Our marriages annulled by decree. Our children are now listed as having only one parent. Some even have their last names erased. This is not just a legal anomaly, it is an emotional wound fixed onto our children's identities. Our families' properties, passed down for generations, were taken as they were nothing. The loss of is not just financial, but existential. Years of savings, building, and dreaming gone. The homes where our children took their first steps, stolen. The farms where our parents worked the land. The businesses we poured our souls into, all stolen. The same happened with Social Security. Decades of contributions erased. For many, especially the elderly, this meant losing their only income. Over 70 retired Nicaraguans of the group of 220 were suddenly left without nothing. I have spoken to them. I have heard the despair of their voices. They feel discarded, forgotten. Statelessness robs you everything, your ability to travel, to study, to work. It follows you like a shadow, even in exile. No passport, no ID, no access to Social Security, no protection from a national consulate. You are invisible. For young Nicaraguan students, it meant losing years of education as their academic registries were erased. They now face the agonizing reality of starting over. That is, if a school wants to accept them without academic records. But perhaps the most painful consequence is family separation. The psychological toll is immeasurable. Being forced to leave our families behind has torn us apart in ways prisons never could. The regime uses our children as hostages, refusing them permission to live and reunite with us. It is deliberately cruelty, inflicted not just on us, but on the innocent. In my case, however, I was fortunate as my wife and my daughter were able to leave Nicaragua and reunite with me the day of the liberation, but I was the exception. I have seen the terrible pain of family separation in my cellmate Roger, for example, who spent an additional year without seeing his two little girls and his wife until they were smuggled outside Nicaragua to Costa Rica and from then allowed to travel to the United States. The Ortega regime threatens our families inside Nicaragua as a way of punishing us for our denounces of the abuses the dictatorship commits. And these denounces, we do it throughout the world. For the about 20 elderly among our group, those who are above 80, the slow legal process to seek for a new nationality is like a death sentence. Without urgent intervention, they might die without ever obtaining legal protection by another state. And yet, in our darkest moments, there was light. Countries like Spain, Colombia, Mexico, Argentina, Brazil extended a hand. Their offer of nationality were more than political gestures. They were acts of profound human solidarity. I became a Spanish citizen in January 2024. I cannot express enough gratitude to the Spanish government and the Spanish people for what they did to us. They gave me not just a passport, but also a sense of protection. Before summarizing some recommendations, I want to tell you what it feels to be a stateless person. All the complications that I have mentioned causes anxiety, distress, and pain. It continuously distracts your attention to solve problems that most people in the world do not experience. To have a valid ID, for example, to demonstrate that you exist and to ensure that your identity is intact. I have never needed to say I felt Nicaraguan as I do now. After 6 years of documenting the violations of my rights and with the help of human rights lawyers, I introduced a petition into the Inter-American Court of Human Rights, and I expect the court to reach a verdict in the coming years. These petitions makes me feel hopeful, and more importantly, that I'm using my energies in finding justice for me, my family, and my colleagues fighting for democracy. Finally, I would like to share some policy recommendations. First, to raise awareness about the international legal framework prohibiting this crime. Conventions constitute obligations for signing countries to respond to the situation and provide practical and coherent solutions to the problems derived from statelessness. Second, as statelessness is often combined with refugee conditions, it is important the coordination of international agencies and governments to identify the key causes and provide logistical and legal solutions. Third, it is important always to keep the advocacy for freedom and denunciation of violations of rights. It is necessary to illustrate the human dimension of statelessness, the suffering of the victims and their families. Fourth, justice. Arbitrary deprivation of nationality usually comes as a result of specific legal actions that can turn be used as evidence of the crime committed by the repressive regime. This makes this crime easier to demonstrate than other forms of repression. Fifth, legal support for victims. To carry these cases into international court systems, resources, both material and human, are needed to bring justice and reparations for victims. Sixth, promote awareness and alert system. More discussions must be around this situation. The role of universities and think tanks is fundamental in the generation of data analysis that help us better understand this phenomenon. And finally, recognize the risk of returning. In a context of more anti-immigrant laws and policies, governments and migration authorities in receiving countries should recognize the great dangers of victims of repression face in returning home, as political violence, discrimination, torture, or even death can be waiting. I sincerely hope that the life-threatening nature of our situation is carried and considered by the authorities of the countries receiving them. Statelessness is, regardless of the causes, the source of an enormous level of distress for families and victims. It is a form of torture, prolonged in space and persistent in time. It can only be solved by changing the conditions that caused it in the first place. It can be mitigated by attending the problem with practical solutions from governments and organizations willing to end the suffering of millions of people throughout the world. Thank you very much.
Thank you very much, Mr. Chamorro, for sharing in such a clear manner your lived experience of deprivation of nationality, identifying the many consequences this has for the enjoyment of so many other rights, identity, and also human dignity. And also thank you for coming up with those 7 recommendations, which I'm sure will be very helpful moving forward. So let's move on now to our second panelists, and I have great pleasure to welcome Dr. Bronwyn Manby, Dr. Manby is a lecturer at the University of London, senior visiting fellow at the London School of Economics, and Africa coordinator for the Global SIT project of the European University Institute in Florence. She is widely published authority on nationality and statelessness, working closely with UNHCR and serving on the board of the Institute on Statelessness and Inclusion. Dr. Manby, you have the floor.
Thank you very much. And can you confirm that you can see my window? I'm sharing my window, yeah?
I can confirm that. Yes, we see very clearly.
Great.
Yes,
Thank you very much. So, thank you very much for having me. It's a pleasure to be here. I am going to talk briefly about the prevalence of discrimination in nationality laws with reference to the right to nationality. And just a reminder to start us off that the Universal Declaration of Human Rights, which is the root of the right to nationality, Article 15 states, everyone has the right to a nationality. No one shall be arbitrarily deprived of his or her nationality, nor denied the right to change his or her nationality. And of course, we have an array of other human rights instruments, both at the UN level and at the regional level, that confirm that this is one of the fundamental rights. As the saying goes from Hannah Arendt, the right to have rights. So if the right to nationality is a right, who is stateless? Who are the people who do not have a nationality? The definition we have is from the 1954 Convention relating to the status of stateless persons, that a stateless person is a person who is not considered as a national by any state under the operation of its law. This apparently simple phrase has a lot of interpretation, and of which perhaps the most authoritative is guidelines from the UNHCR, now in the Handbook on Protection of Stateless Persons, which says that you have to see this analysis of who is stateless as a mixed question of fact and law. And in particular, therefore, there are two elements that are causes of statelessness. On the one hand, there are problems with the substantive laws. And I must highlight here that we're not talking only about the main nationality code, the main Citizenship Act. And just to say that in international law, nationality and citizenship are used as synonyms. But family laws may be relevant, laws about procedure, about evidence, laws about, there are many other types of laws about identification, about passports may also be relevant in terms of looking at whether a person is stateless. And then you must almost also look at the procedures, and especially questions of proof of status. But these procedures are also often set out by law, most notably laws on civil status and civil registration, but also internal departmental directives, which are a form of law, subsidiary legislation, decrees. There's a whole complex of different types of law and factual procedures which may be relevant in determining and therefore in causing statelessness. And as a fundamental cause of statelessness across both law and procedure, we must look at discrimination, as noted in the Human Rights Council resolution, which is the basis of this workshop. So what I'm going to do next is look at a global comparison of nationality laws. And I must emphasize here that in the information I'm going to show you, I'm talking about actually the nationality laws, the main Nationality Code or Citizenship Act. And as I have just stated, you have to look much beyond that, but it's much harder to come up with a comparative set of tables if you're looking at civil registration or laws on identification or passports. But this will give you a sense. So to start off with, looking at all discriminatory provisions in nationality law. And here I am combining both discrimination based on sex and discrimination based on characteristics such as race, ethnicity, or religion. So the good news is that if you look at all nationality laws in the world, and this is taken from the Global Citizenship Law data set, which has comprehensive comparisons of modes of acquisition and loss of nationality across 191 states. The good news is that 90% of states do not have explicitly discriminatory provisions in their nationality laws. 10% do. There's then, in the bar chart, a breakdown by region. So European countries, this is the UN definition of Europe. We have 0 that are explicitly discriminatory. We have around 45–46% in Africa and Asia, so under half, but still quite substantially provisions that either discrimination based on sex or discrimination based on race, ethnicity, and religion. We have lower percentages in the Americas and Oceania. Zooming in on discrimination based on sex, this table is from the UNHCR background note on gender equality, nationality laws, and statelessness, the most recent edition. It's published annually. And if you see here, we have 20 countries that are still 24 countries that are still discriminating. Malaysia is grayed out there because a law has been adopted to remove discrimination based on sex, but it's not yet in force. And otherwise, the countries in red have the most severe forms of discrimination based on sex. In some cases, almost no possibility for a child to acquire nationality from its mother. If born in wedlock, and vice versa if born out of wedlock, but in some cases not even then. Orange is medium discrimination. Mauritania is a lighter form of discrimination. But so we have, the trend to remove discrimination based on sex is very strong, and every year we are having 1 or 2 countries that are removing this type of discrimination. So the direction of travel is very positive. If we look at discrimination based on race, ethnicity, or religion, it's much harder to do a table because the provisions are much harder to analyze and codify. But we do have 4 countries globally where there is an absolute prohibition in law on children acquiring nationality unless they are a member, or adults even by naturalization, unless they are a member of a certain race, religion, ethnicity, and so forth. And these are Brunei, Liberia, Sierra Leone, Uganda. Sierra Leone, you can naturalize as an adult, but your children do not acquire citizenship at birth. There is a generalized provision with some exceptions, so the impact in practice is not very clear. From Democratic Republic of Congo, Eswatini, Myanmar, Nigeria, Uganda, Somalia, and South Sudan. And because Sudan says it deprives nationality from people who have acquired South Sudanese nationality, you have a form of ethnic discrimination encoded in the Sudanese law as well. Much more common, more than 50 states, is a provision for facilitated access to nationality, an easier form of naturalization based on some form of cultural affinity. Now, this in itself is not necessarily problematic. Historical connections, for example, linguistic, ethnic connections providing an easier route to acquire nationality, perhaps somebody who's the grandchild of a person who used to have citizenship. But in some states, this is effectively only the route that is accessible. And in that context, it is, of course, problematic because it becomes restricted only to the group with cultural affinity. But it's very hard to know how that works in practice, looking only at the law. In reality, we know that discrimination based on these grounds is pervasive in all states. And it's often disguised in apparently neutral procedures around producing, for example, birth certificates, when it is well known that people living in certain areas or members of certain religions cannot produce a birth certificate of their parents because there was no birth registration in that region or for that group at the time their parents were born. So the procedure looks neutral, but it has a discriminatory impact in practice. And I also just want to note that while the system of nationality based on descent or based on birth in a territory varies across the world, and there is freedom to choose either system with restrictions based on the avoidance of statelessness. But where you have a purely descent-based law, and in addition, naturalization is impossible to access, except perhaps for certain groups, then over time, statelessness is likely to be the result. Because after multiple generations, if the children have no rights based on the birth in the territory and the parents cannot naturalize, you will end up with statelessness because they will lose any connection to a country of origin. I want to highlight briefly the importance of post-colonial context as we look at statelessness. And in particular, if we look at the groups who are at risk of statelessness, are very often some form of fallout from the history of colonization, especially, but not only, by European powers. So on the one hand, we look at the descendants of pre-colonial or colonial era migrants. So if we look at, for example, people brought as forced labor, indentured labor, other forms of coerced labor, brought into a territory to work, but never documented as citizens on the attainment of independence. We can also look at contemporary migrants, who are a category of people at risk of statelessness, especially those who do not have identity papers. They are not necessarily stateless because they have no identity papers, but if, for example, they then have children and they don't have an identity documents themselves, and therefore they cannot register the birth of their child, statelessness can be the result. Asylum seekers and refugees are not necessarily stateless, but former refugees where the cessation clause has been invoked, but they cannot establish either naturalization or connection to a country of origin, are definitely likely at high risk of statelessness. We look at cross-border populations, and here again, as with the pre-independence migrants, the colonial history becomes especially relevant, although of course communities are divided by international borders in other contexts as well, but it's particularly significant in a continent such as Africa, where the borders were drawn with no regard for pre-existing political boundaries. Contested borders exist everywhere, and we see citizenship being contested where that is the case, and people of nomadic origin or who are currently nomads are often also, because never documented, never regarded as belonging to one particular state, are at risk of statelessness. But it is important that it's not only those who are actually currently nomads, but people whose last name, for example, suggests that their ancestors were nomads, who, because of discrimination, find themselves excluded. We have also vulnerable children, who I point out become adults. They were vulnerable as children, but because they were vulnerable as children, they do not acquire nationality and remain stateless as adults. These are those whose parents were stateless themselves, parents without a documented legal status, those born out of wedlock, abandoned infants, orphans, street children, the trafficked. A whole category of people who, if their situation is not resolved while they are children, and often reason for non-resolution may be underlying discrimination, are left stateless. And over all of these, we have the impact of discriminatory laws or legal gaps and discriminatory procedures. So what is the impact of statelessness on the enjoyment of human rights? We've looked at the causes and the importance of discrimination as a cause of statelessness. But looking at the impact, the first two, and those that are, as it were, permitted by the international human rights regime, are freedom of movement. So the International Covenant on Civil and Political Rights, Article 12, states that everyone has the right to return to his own country. The Human Rights Committee has clarified that a person's own country is broader than the country of their nationality. But if you do not have a document of nationality, that will become difficult to prove. And as we have just seen from our colleague Juan Sebastián Chamorro, political participation is a casualty of the denial of the right to nationality and of statelessness. But the impacts are much broader. Although human rights are stated in most cases to belong to everyone, we can see that the impact of statelessness is severe on enjoying equal protection of the law, on the right to liberty, freedom, and freedom from arbitrary arrest. Stateless people can find themselves in indefinite immigration detention. It has impact on freedom of speech, assembly, and association because of the fear of arrest if a person raises their voice. And we also have impacts on a wide range of economic and social rights, including housing, work, education, and healthcare. And finally, at the biggest picture level, impact of statelessness on individual human dignity, that sense of being recognized as a person with a voice, with a right to belong, and on peace. We see in many regions of the world how denial of nationality has led as a proximate cause of conflict. And therefore the resolution of who belongs, who is a member of this state, is also often an essential element of a peace agreement. So what are the solutions? Here we must divide stateless people into two categories. So persons of undetermined nationality living in their own country, by which I mean the country where they have the strongest connections. And in this context, they must either have their existing nationality under the law confirmed. If they have not been able to prove the facts, there should be ways of enabling people to adduce different types of evidence to prove the facts that show that they are in fact a national, or there should be facilitated acquisition of nationality as provided for under the Convention on Protection of Stateless Persons. In the context of stateless migrants, we must look at confirmation or acquisition of nationality of a country of origin. And here the role of consular assistance becomes very important. Or alternatively, if that is not possible, protection as a stateless person with facilitated naturalization as provided for in the 1954 Convention on the Protection of Stateless Persons. But since we are looking at two forms of discrimination and two forms of problem that lead to statelessness, both law and procedures, we must look at reforms to achieve these two results, both of law and of the procedures. So in relation to law reforms, a removal of discriminatory provisions, at least minimum rights based on birth and residence in the territory. That is to say, in particular, that a child born in the territory who cannot acquire nationality from a parent should be able to acquire the nationality of the state of birth. There must be reforms around the burden of proof and the types of evidence accepted, and importantly, rights of review and appeal of administrative decisions. Also a need for procedural reforms. The first and most important, universal birth registration. That is to say 100%, not 99%, but 100% of all children have their births registered. And procedures put in place of child protection, especially for children separated from their parents, to ensure that there is a process for registration and confirmation of identity. A need for outreach to excluded groups, for legal and paralegal assistance, for access to consular assistance, or alternative routes to prove citizenship. And where possible, in some cases this is politically impossible, but where possible, interstate collaboration to resolve undetermined nationality. And I'll conclude there and just to note that there is a hyperlink here to a blog post in which I have discussed these issues in a bit more detail. Thank you very much.
And thank you, Dr. Manby, for walking us through both the prevalence of discrimination in nationality laws, some of its manifestations, and also the impacts this has on a range of different human rights, both civil and political and economic, social and cultural rights, and of course, identifying some of the solutions including for law reforms. So I thank you for that presentation and move on now to our third panelist. And this is Mr. Subin Mulmi. Mr. Mulmi is a human rights lawyer, researcher, and executive director of Nationality for All, an organization based in Nepal advocating for the right to nationality across the Asia Pacific. Mr. Mulmi, you have the floor.
Thank you so much. A difficult act to follow, both Mr. Chamorro and Bronwyn. I can see that Bronwyn's already addressed some of the points that I was trying to make. So I'll sort of not spend too much time on things that are already covered and try to focus more on the context of Asia Pacific and how discrimination plays out in the nationality laws and practices in the Asia Pacific, and also try to sort of share some sort of specific insights on a few countries on the intersectional forms of discrimination in nationality laws and practices. So I have a presentation. Let me share my presentation with you. Hope you can see this. Okay, great. So just quick introductions of the work that we do. So Nationality for All is a regional organization that works to promote right to nationality and address statelessness in the Asia Pacific region. I'm based in Nepal, but the organization is registered in Australia, but we work throughout the Asia Pacific region. And we're a fairly new organization, just I think 4.5 years now. We were previously known as the Statelessness Network Asia Pacific, which was a regional network of civil society organizations. So we're not a network anymore. We're a partnership-based organization, and our main sort of goal is to strengthen the fair and meaningful participation of stateless activists and persons with experience of statelessness in addressing the issue of statelessness. So just a quick overview of statelessness in the Asia Pacific. As of 2023, Asia Pacific region is home to an estimated 2.5 million stateless individuals, according to the UNHCR Global Trends report, which is 50% of the global stateless population. But let me note that this is the number is a severe underrepresentation, underreporting of the number of stateless persons in the region. The actual number can be presumed to be much higher because many countries in the region do not report stateless populations to UNHCR or report zero stateless populations, despite a lot of evidence suggesting otherwise. And there are several reasons behind the underreporting. I don't want to get into all of that, but I just want to sort of let you know that the region has a huge number of stateless persons, and some of the reasons the massive number of statelessness in the region is already highlighted by Bron in the last presentation. I'm going to repeat that, but I'll just sort of quickly talk about the citizenship law in the region. When you look at the Asia Pacific and we're counting, we're looking at 45 states in the region, and most countries have a jus sanguinis or citizenship by descent form of citizenship system. So it's citizenship is acquired through the citizenship of a parent. So, and out of that, 22 states provide that children born to a parent can gain citizenship with no distinction based on the country of their birth, whereas 17 states in children can gain nationality where a person is a citizen of the relevant country. However, there is a distinction based on the country of the birth. There's separate provisions for children who are born in the country and separate provisions for children that are born outside of the country. The two countries that provide that citizenship can be transferred to children if both the parents are considered citizens. And there are 4 countries, Brunei, Kiribati, including Malaysia here as well, even though they made a recent amendment, and that's, I think, pointed out in the chat box by Catherine as well. So, and I'll sort of get to why I put Malaysia in there. And there's Nepal that have, discriminatory provisions for women in terms of transferring or conferring nationality to their children. And there are 9 countries that limit the ability of married women to confer nationality onto their non-citizen spouses on the same basis as men. So So I'm going to talk about discrimination in nationality laws, and then I'll talk about discrimination in practices. And I think I'll focus more on the practices because a lot of the legal discrimination has already been covered. So in terms of nationality laws, where they specifically in the law itself exclude certain ethnic groups or certain groups, Myanmar and Brunei, I think one has already talked about this. In Myanmar, there's any group that is not included in the list of 135 ethnic groups that are recognized as national races are denied the right to citizenship. The Rohingyas fall under this group as well. In Brunei, there's limitations of nationality to certain, ethnic groups or indigenous groups of the Malay race. So now getting into the gender discriminatory nationality laws, that as I said, it's in Nepal, there are separate kinds of citizenship and citizenship acquisition process for children that are born to a Nepali mother or and a non-Nepali father, or a father who cannot be traced, or and there's a separate provision for if the child is born to a Nepali father. And I'll not get into the details because I think Ivana, the next presenter, will talk more about this. On Malaysia, the reason I mention this is also because because there is a discrimination for Malaysian men who can't confer citizenship to their children that are born out of legal marriage or that are born out of wedlock. In Malaysia, there was a recent amendment, constitutional amendment, that allowed Malaysian women to pass on citizenship to their overseas-born children. But despite this fact, this is not applicable retroactively. So there are still many children born to Malaysian women and non-Malaysian men outside of the country before October 2024 who are not eligible to get the citizenship. So Brunei, in addition to having ethnicity-based discrimination, also has gender discrimination. And Kiribati is another country that has a similar provision, or used to have a similar provision to Malaysia. So in terms of policy and practice, it is really important to understand that just because there is a legal entitlement to citizenship, it does not always guarantee access to citizenship. And even when it does guarantee or results in access to citizenship, it may not result in being treated as equal citizens with the same rights as other citizens. So there, in the region, there are quite a few examples of certain communities that, so because of the procedure and practices by the bureaucrats, even though they have legal entitlement, they're always asked for additional documents. They face a lot of discrimination and humiliation and so derogatory treatment by the bureaucrats, and sort of a few communities already mentioned here. And in certain contexts, as you can see here in the case of border tribes in India, in the case of ethnic Vietnamese in Cambodia, some of the nomads in Cambodia as well, the Hmong community in Laos, and there are other sort of, these are just a few examples of few communities. Not only they're required to sort of present additional documentations, which is impossible for them to present. This could include a birth registration. This could include, educational certificates, which is really difficult or impossible for certain communities. And those are sort of specifically in terms of practice required for certain communities. And like I said earlier, so there's also discrimination in accessing rights as equal citizens, even after acquiring nationality. A prominent example is the Urdu-speaking minority in Bangladesh. After decades of legal battle and activism, they were finally able to change the law, and they are eligible or entitled to get Bangladeshi citizenship. But even after getting the citizenship, because of the fact that they still live in camps, they're still discriminated, they still don't have access to the same access to property rights or other forms of rights as well. In the case of Hmong ethnic groups, they don't have the same access to education or health. And there's so many other examples of other different communities as well. Something that Bronwyn already sort of spoke about in terms of colonial legacy, and I want to sort of acknowledge this as well. In the Asia-Pacific region, most of the region was colonized, and not only the fact that the borders were sort of drawn up arbitrarily, sort of undermining the different ethnic and linguistic realities, but the many sort of post-colonial nations also inherited the discriminatory legal frameworks. And one of the prominent example is the gender discriminatory laws. It's no surprise that the 4 countries that have gender discriminatory citizenship laws that can't pass on citizenship to children in the same capacity as men were either colonized by the British or were under sort of influence of the British colonial regime. The dissolution of the USSR in particular has created a lot of statelessness in sorry, I'm not sure if someone unmuted, but yeah, moving on. So yeah, in Central Asia specifically, there were communities that have been marginalized and have been at risk of statelessness, or have been stateless for a long time. The other important sort of thing that needs to be mentioned in this region is the formation of, after colonization ended, the formation of ethnocentric or ethno-nationalist states that prioritized one dominant ethnic identity as sort of encompassing, or as representing the national identity, that resulted in preferential citizenship laws, cultural and linguistic hegemony, and overall exclusion of minorities from governance. And this narrative of ethnic and national purity that can be seen in most of these countries, and this strong resistance to multiculturalism. And again, every time we talk about citizenship, it's always equated with national security. And I want to sort of briefly talk about the intersecting forms of discrimination and sort of take a case, sort of example of Nepal, where Nepal is a landlocked country surrounded by India and China, 2 largely populated countries. And in Nepal, there's a strong anti-India sentiment. There's a bigger influence of India compared to China. And the people in the southern part of Nepal, that are called the Videshi community, are sort of most affected by the anti-India sentiment, because they are not sort of the majority of the dominant ethnic groups, the dominant groups. There is this strong discrimination against the Videshi community because of the social cultural ties with India, and also because of the open border with India and the practice of cross-border marriages. However, if you look at the law, there's no issues providing citizenship to a foreign female spouse. There's actually, in fact, an expedited process to provide citizenship to a foreign female spouse. In this case, it is mostly Indian citizens who get married to a Nepali man, and they're immediately provided citizenship. And I'm not saying that's the wrong practice at all. That is what it is, which is amazing, which is actually a good practice. However, that is not seen to be, or never projected to be, a national security risk. However, and the risk is always presumed to be for men and children of Indian men, or children of foreign men and Nepali mothers. And then that sort of reason is given, or that sort of excuse of national security then results in the restrictions of women to pass on citizenship rights, even though cross-border marriage is maybe not a common practice throughout the country. But in the guise of national security, it is in fact the patriarchal sort of mindset of the lawmakers that result in this in this restrictive form of citizenship. And you can see multiple layers of discrimination that is faced by the Videshi community because of the ethnic identity as Madeshis that have social cultural ties, and also specifically for Madeshi Dalit community, who are also sort of from the so-called lower caste groups that have no access to power, that have no access to land, and are not represented enough in the governance. And at the same time, the Madeshi Dalit women, who then sort of suffer even more. So, we only talk about laws and policies and look at it from a human rights perspective at times, but it's so important to look at it from a governance perspective. Also look at the form of governance that sort of, regulates or, is responsible to issue citizenship certificates. In most countries in the region, because of corruption and a centralized governance structure where citizenship is provided in the central city, or people have to travel a lot of distance, these also act as certain barriers for people to exercise their nationality rights. And we can see in most countries and where citizenship is always used as a political tool, right before elections, citizenship is an easy political agenda or election agenda, and there's always sort of narratives to restrict citizenship laws, to protect national security, and that becomes a really populist agenda during elections. Most recently seen in many countries like India, Nepal, and sort of so many countries. And a really important thing, like I said, we look at citizenship or nationality as a human rights issue, but it has not, in fact, been established as a right in the region, but merely as a privilege granted by the state. A lot of conversation still needs to happen, and many states still are yet to sort of fully realize or understand that it is a human right. So to conclude, I think sort of things that have already been said, it is really important to understand that the structural and historical roots of discrimination. We should not look at discrimination merely as a cause of statelessness. Yes, it is, but also try to understand the root causes of discrimination as well, and try to address those root causes of discrimination. And at the same time, strengthen documentation and also strengthen governance practices as well. Focus not just on legal reforms, but also how to ensure reforms in practice. And most importantly, and something that Mr. Chamorro's sort of presentation sort of focused on, for me as someone who has never been stateless, I don't fully understand what the implications of these things are. And I have, experience in terms of learning about it and worked on this, but it's always the stateless persons themselves who fully understand the repercussions and the causes of statelessness, and they should be the ones that are centered and should be the ones actually, in fact, which are leading the process to result in those work on those reforms. So that's it. Thank you so much for listening. If you want to learn more, there's a website that you can sort of go through. We also have a report on this that has country fact sheets for all the 45 countries in the region, sort of in-depth analysis on the status of statelessness in the region, the causes of statelessness. Thank you so much again for the opportunity. I'll sort of stop now. Thank you.
Thank you very much, Mr. Mulmi, for advancing our discussions by having a deeper analysis of a particular region, the Asia-Pacific region, and including, of course, the discussion on intersectionality in Nepal itself. And I think also for highlighting some of the practical barriers, not only legal barriers that can lead to arbitrary deprivation of nationality, but practical barriers such as administrative decision-making. And of course, identifying root causes of discrimination, which is always very important in drawing the conclusions and the solutions to the issue. So thank you again. And I would like now to move on to our fourth and final panelist, and this is Ms. Ivana Kristic. Ms. Kristic is a distinguished human rights scholar, professor at the University of Belgrade, and a member of the UN Working Group on Discrimination Against Women and Girls. She has served as an expert for numerous organizations and is widely published on issues of non-discrimination, gender, and refugee law. Ms. Kristic, you have the floor.
Thank you so much. Can you just confirm that you can hear me?
We can hear you very well. Thank you.
Okay, thank you so much. So first of all, good afternoon. And thank you so much for this opportunity. I'm really honored to address you today on behalf of the Working Group on Discrimination Against Women and Girls. And also, I need to congratulate you on a topic that is really very important. I hope that, I don't know, I also hear some additional sound. Is everything fine?
Everything is fine now. Yes.
Okay, okay, thank you. Okay, thank you so much. So, as I said, to congratulate you on a topic that is very important and that really lies in the intersection of legal identity, human dignity, and the enduring fight against gender-based and intersectional discrimination. And my speech will be related to gender equality and gender discrimination in this regard. We already heard that nationality is not merely a legal status, and it is a foundation for the enjoyment of various human rights. We've already seen Article 15 of the Universal Declaration of Human Rights, which is really a basis which provides protection in and also international standard in this regard. But I would also like to mention Article 9 of the CEDAW that call upon states to grant women equal rights with men in acquiring, changing, or retaining nationality and in conferring nationality to their children. And also very important article that we sometimes neglect, and this is Article 2F of CEDAW, which requires states to modify or abolish laws, regulations, customs, and practices constituting discrimination against women. We've already heard that still women and girls around the world continue to face discrimination in nationality laws and practices. However, at the root of this problem is not only legal, but we also heard procedural and structural barriers as well. And when we speak about discriminatory legal provisions, we mentioned that some nationality laws are still discriminatory. And when we talk about women, that discrimination usually is in terms of inequality in conferring nationality to children or spouses, loss of nationality upon marriage or divorce, dependent nationality regimes when a woman's nationality is tied to her husband's, and also in terms of gendered rules on dual nationality, as women may face stricter restrictions than men in holding or transferring dual nationality, limiting their mobility and legal protections. But also we've heard that a legal issue is only one problem here, and that also many women and girls are facing administrative or procedural practices which are discriminatory in its nature. And here I would like to mention some barriers, such as documentation requirements, guardianship and consent restrictions, but also something that was mentioned by Subin, and thank you so much for raising this issue, and this is bureaucratic biases and corruption as well. All these issues and hurdles create additional layers of exclusion for women trying to navigate already complex nationality systems. And also, we shouldn't neglect structural and intersectional barriers. Beyond law and administration, structural inequalities and intersecting forms of discrimination magnify the challenges women face. We've already heard about challenges which are facing both women, but also by other groups, and women are also very much affected even in those general terms. And here we've heard about conflict and displacement, and definitely displaced, refugee, or stateless women often lack access to civil registration and nationality determination procedures, increasing their vulnerability and raising their legal personhood. But also, women from low-income backgrounds or rural communities may not afford the travel costs, administrative fees, or time needed to access legal institutions. The lengthy, often costly citizenship application processes disproportionately impact women. In addition, women from ethnic minorities, indigenous women, and migrant women often face compounding discrimination, resulting in disproportionate exclusion from nationality rights. Many women are unaware of their rights or unable to navigate bureaucratic systems due to limited literacy, legal support, as majority of countries have very restrictive laws on free legal aid, for example. But also we've heard that language barriers can be very significant. All these structural conditions ensure that the most marginalized women are also the most likely to be stateless, and at the same time, the least likely to be heard. The consequences are profound and lifelong, and we've already heard how it affects and how it hinders the realization of various other rights that we underlined as a working group in one position paper that we published in 2017. And here I would like to inform you more about the different issues which were covered by and activities covered by the working group itself. Recognizing the multiple harms caused by discrimination against women in terms of nationality, the working group has consistently highlighted the detrimental impact of discriminatory nationality legislation in its thematic reports, raised concerns with respect to lack of progress on the issue during country visits, and also advocated for legal reform in our communications. I would like to mention our report on family and culture, where we clarify that in some countries, legislative provisions reinforce patriarchal family structures, perpetuating discrimination and violence against women. We underline that when only men are able to transmit their nationality to their foreign spouses and the children, this de jure inequality has considerable effect on women and their children because the state protection granted by citizenship is refused to them de facto. And I think that this is very important to remember. Also, I would like to mention another thematic report that we wrote on discrimination against women in public and political life. And I'm also very happy that in the beginning, we also mentioned that how it can hinder the participation of women in public and political life. And the working group underscores that citizenship and nationality status condition and define women's ability to participate in all aspects of life, including public and political life. But as we are aware, some nationality laws frequently discriminate against women, particularly through provisions that impose a single nationality within a family, often rendering the wife's nationality subordinate to that of her husband. In such contexts, women may lose their nationality upon marrying a foreign national, especially when both countries adhere to the principle of dependent nationality. Where the husband's country does not recognize this principle, women risk becoming stateless, depriving them of the right to participate meaningfully in the political and public life of any country. The gendered consequences of statelessness are severe and far-reaching. Stateless women and girls are at greater risk of early and forced marriage, sexual exploitation, denial of maternal health care, inability to own or inherit property, and also barriers to accessing justice and legal protection. Lacking recognized legal identity, they live in a state of perpetual legal and social exclusion, which amplifies other forms of discrimination they may already face. I would also like to mention that laws that require women to obtain the permission of their husbands or male guardians to acquire passport or identity documents severely curtail their autonomy, restricting their freedom of movement and by extension their ability to engage in public life. The report also highlights how intersecting forms of discrimination have a compound all these challenges that I already mentioned. And I would also like to underline that in recent years, some states have repealed or amended discriminatory nationality provisions that we've already heard. However, and also I would like to mention that some countries have lifted the reservation to Article 9 of the CEDAW that I already mentioned. So we have some positive changes, which are also followed by legal challenges in courts and human rights mechanisms. However, discrimination against women and girls in nationality is still persists. And through our communication procedure, the working group has urged states to amend discriminatory provisions and align them with international human rights standards. In 2014, so 11 years ago, we issued a series of communications to 26 states on this matter. We are currently starting a follow-up series and have recently issued one on Malaysia's constitutional amendment bill that was already mentioned, so I will not lose more time on this. But I would also like to underline that during our most recent country visit to Thailand, for example, in December 2024, we noted disparities in nationality transmission requirements between Thai men and women. A Thai woman can only pass on her citizenship to a foreign husband if he fulfills extensive requirements, such as knowledge of Thai language, regular occupation, and being domiciled in Thailand for 5 years. We recommended that the government revise all gender discriminatory provisions in existing legislation. Similar issue was also raised in another country visit, for example, in Mauritania in October 2023, where we regretted that the nationality code still contains discriminatory provisions and reiterated our recommendations and that of other human rights mechanisms to ensure that Mauritanian women have equal rights in transferring their nationality, including to their children born abroad and to a foreign spouse. So what is necessary to be done in order to improve the situation and to try to move all these barriers? And I would say that there is an urgent need for inclusive, equitable, and gender-sensitive citizenship laws, which also requires that all discriminatory nationality laws must be urgently repealed. But also it is not enough, and it's clear. So civil registration systems must be made universal, inclusive, and gender sensitive, and reforms must go beyond infrastructure to address gender realities. For instance, ensuring that women can register births and marriage independently without needing the consent or presence of male relatives. Also, statelessness, determination, and nationality acquisition procedures must be explicitly gender responsive. This means recognizing and accommodating the specific obstacles women face. What can also be done is that, for example, it was already mentioned by some of my predecessors today, and this is that we must invest in the collection and publication of sex-segregated intersectional data. Experience has shown that without accurate data on stateless women and girls, particularly those from marginalized communities, policy responses remain inadequate. And finally, and most critically, we must center the voices of stateless and at-risk women and girls in every aspect of legal and policy reform. Their lived experience is often essential insight into the failures and gaps of existing systems. I would like to conclude today saying that the working group will continue to collaborate with states and civil society to advocate for comprehensive reforms, empowering women and upholding their rights, and allowing them to confer nationality to their spouses and children equally with men, and ensuring that women and girls everywhere can enjoy their full rights and contribute to building just, inclusive, and equitable societies for all. Thank you once again for this opportunity, and I'm really looking forward to our discussion.
Thank you very much, Ms. Kristic, for raising the issue of Article 9 in CEDAW, of course, and also the important work of the working group, your work on communications, your country missions, and of course your thematic reports on family and culture, and also on public and political life. So that brings us to the end of our panelists. We will extend the session just by 5 minutes so we can have a bit more time for discussion, and I'll quickly go through how we should proceed. First of all, if you wish to take the floor, please press the raise hand button on your screen. I will then ask my colleagues to unmute you so that you can intervene. Please note that pursuant to Human Rights Council Resolution 5316, today's event is an OHCHR event. So we do not necessarily follow the Human Rights Council rules of procedure in the event. That being the case, we will initially take interventions from representatives from permanent missions to the United Nations office at Geneva, as well as ministries, followed by stateless or formerly stateless persons, and then we will then open the floor to all other participants. In order to allow a maximum number of interventions, please limit interventions to 1 minute each. You're also encouraged to use the chat box, and of course I hope there will be an opportunity for a discussion at the end of the end of panel 2 as well. So I open the floor, and I see that there are already some hands up, so my colleagues will give me the names of. Just give me the country. Okay, so I will give the floor first of all to the representative of Malaysia. Apparently, the speaker is not connected for the moment, so we will go on to the next speaker. And, oh,
hello,
please,
can you hear
yes?
me? All right, fine.
This
Sorry.
Yes, please.
I didn't notice. I didn't click unmute.
That's okay, madam.
Okay.
Oh.
So basically, I understand this whole idea of possibility of conferring nationality to spouses, when you got married, is just ideally for the nationality to be transferred to the spouse as well. However, I do have a question when it comes to the policy of dual nationality. You see, I've seen a lot of cases whereby when you have that kind of policy you allow dual nationality of a person, there is going to be people who take advantage on that. People who got married for convenience, for example. So how do states, what are the recommendations that is available, especially at the United Nations level, with regards to addressing this issue of exploiting especially the vulnerable people like the older generation and such, due to the fact that there is such thing as dual nationality? And secondly is that when you have dual nationality, wouldn't that kind of like give the country of origins that sort of like endorsement for them to do a systematic ethnic cleansing? We saw that already when a country does not recognize their national, and their national actually ran to another country, while other countries actually recognize them as the national of the country of origin. They kind of like brush it off and say, look, we are not going to give you nationality because we so-called do not recognize you under our constitution. Wouldn't that be considered as a systematic ethnic cleansing? And wouldn't the dual nationality policy or automatic conference of nationality because of being born in a different country is considered as a systematic nationality? So I really hope that I can get some answers on this. Thank you.
Thank you. We will move on now to our next speaker. We do not have any other representatives of the states or ministries who would like to take the floor, so we will move on to the broader list. And the next person on my list is Sandra Ratchin. Sandra, you have the floor.
Sorry, can you hear me now?
Yes, Sandra, we can.
Yes.
Please go ahead.
I'm sorry. Thank you so much for giving me the floor. I'm representing the International Commission of Jurists, and I really would like to thank very, very much the OHCHR for organizing this meeting, but also the speakers of the first panel for very insightful and really excellent presentations. As you said, we have very limited time, so at this stage I really wanted just to flag one document which is obviously important for ICJ because of the input and contribution that we made to that document, and that relates in particular to the first intervention by our colleague from Nicaragua, Mr. Juan. And it's just to remind everyone about the existence of the principles on deprivation of nationality as a national security measure. They were finally adopted in 2020 after a long process of research by legal experts. And I think these principles still hold a lot of relevance for the discussion today. And so I think it would be great. I will post again the title, maybe the links in the chat, just in case it's important or interesting for people. And just because these measures are far from being less used nowadays, especially and also for dual nationals, and they bear a lot of discriminatory impact in and of themselves, these kind of measures and deprivation of nationality for supposed security purposes. So I leave it at that, and I will post something in the chat. Thank you so much for giving me the floor.
Thank you very much, Sandra. And moving on to our next speaker is Matt for Peace. Madam, you have the floor. You're muted. Could you? You're muted. If you could unmute yourself, please. Unfortunately, we cannot hear you. But you seem to be unmuted, but we cannot hear you. Could there be a problem? No, unfortunately,
You can share that.
no, unfortunately, we cannot hear you. Maybe if you could, well, I do apologize for this, but maybe if you could share your comment in the chat, and of course there will be some time for discussion at the end of the panel too as well. But my sincere apologies. Are there any other people who would like to take the floor? No. Okay. Well, that brings us directly to 3:35. So we will close the panel here. I do notice that there was a question. The question has been noted, and okay. Well, maybe just 1 minute. I see that one of our experts would like to take the floor. So, Mr. Manby, if you'd like to respond to that question.
Literally, just to direct people's attention to the response from Catherine Harrington in the chat about the point on dual nationality and discrimination based on sex. And to add my own comment is that the profile of people who are stateless and the profile of people who might have dual nationality is very often identical, except that the people with documented dual nationality are rich and the people who are stateless are poor. And the responsibility of the state that asserts that a person is a dual national is to determine that it is in fact the case. And if that cannot be proved, the person should be treated as a stateless person and offered protection as such. Thank you.
Thank you very much, Doctor, for that response. So that brings us to the end of this first panel. We won't have a break, given that we have only limited time, but I will I do have great pleasure handing over to my colleague, Ms. Monica Sandvik, who will be moderating the next panel. So thank you very much for the panelists and also to the participants for your questions. Thank you.
Very pleased to moderate the second panel. Was very listening with great interest to the first one, and we are shifting gear a little bit here now. So more looking at practical examples, good practices from a number of countries, how they have addressed statelessness and tried to implement the right to nationality. So we have, for this panel, we have representatives from Thailand, Egypt, Kenya, and Chile that will share their experiences with us. The bios, as was already said during the first panel, are also on the website. So I will be quite brief when it comes to introduce the speakers. But I will move straight into the first speaker. It's with great pleasure I wish to introduce Ambassador Usana Berananda. She's the permanent representative of Thailand to the United Nations and international organizations in Geneva. I would like to hand over to you, Madam Ambassador, with this for your intervention.
Thank you, Monica. Good afternoon from Geneva, and I would like to thank UNHCR for organizing this expert workshop. It is really timely, and I had a pleasure to listen to the speakers during our previous session and have learned a lot. Thank you very much for sharing the insights. In the case of Thailand, we are one of the, I have the presentation. Let me see whether I can share that.
Yeah,
Can you see the presentation?
Cannot see it yet.
But we can share it from our side.
We can share it from our side if you just indicate when we should shift slides. So
yes,
it's coming up here.
Yes.
over to you.
Okay, thank you very much. So in the case of Thailand, we have one of the world's largest stateless population in our country. According to the UNHCR, we are the fourth largest after Bangladesh, Cote d'Ivoire, and Myanmar. In 2024, there are more than 400,000 people registered under the UNHCR, and most of them live along the border provinces between Thailand and Myanmar and Laos PDR. Next slide, please. Okay, and if we want to talk about the efforts, our journey in addressing statelessness, it's a very long and challenging journey indeed. As I mentioned, we have the fourth largest stateless population in our country, and almost 500,000 people are registered under the UNHCR. But with that, we are committed to provide assistance, protecting stateless persons and trying to resolve statelessness in the country. And since 1992, we have granted more than 300,000 stateless persons with Thai nationality. And from our experiences resolving statelessness, next slide, please. Okay, it requires a multi-stakeholder, whole of government, whole of society approach. Dr. Manby mentioned about the solutions, both law reform and the procedural reforms. We have been through that at all levels. I'd like to mention, our efforts in the three levels. First, at the international level, Thailand recognizes the importance of active engagement with various stakeholders, UNHCR, the international community, other international organizations, as well as the civil society organizations. The cooperation and supports with all these stakeholders are really important in addressing statelessness. We are the founding member of the Group of Friends of the I Belong campaign, and last year we also joined the Global Alliance to End Statelessness. And we also made pledges at the Global Refugee Forum, which lay out a clear direction on what on the policy that we want to implement and the goal that we would like to achieve each year, which really help us, in implementing all the policies that involve various stakeholders in our countries. At the national level, we have made both legal and procedural reform. For example, a national strategy on administration of legal status and rights of persons was put in place in the year 2005 to expedite status determination for ethnic minorities and other unregistered population living in the country, as well as to promote access to basic rights and public services. And these include access to education and healthcare. We have made reform with regard to our civil registration system, including amending the Civil Registration Act and taking steps to increase efficiency and trying to streamline the process, make it easier for stateless person to apply and acquire Thai citizenship. We try to streamline the process, and this involved the delegation of decision-making from the central government to the provincial and local or district administration, in order to avoid the unnecessary stress, to send a document back and forth, reduce time for the application, and this is really important because it can help expedite the process in the acquisition of nationality. And most importantly, in October last year, the Thai cabinet has made a historic decision to approve a resolution to expedite the pathway to permanent residency and nationality for stateless population. This resolution aims to grant more than 300,000 permanent residents to long-term residents and member of stateless population who have been in the country, and after 5 years they can also apply for Thai nationality. And the resolution also aim to grant Thai nationality to over 100,000 children who were born in Thailand to stateless parents. So any children from stateless parents who were born in Thailand, they will, in the future, they will get Thai nationality. And the resolution also aim to streamline criteria and shorten the approval process. For example, in the past, if you want to obtain the permanent residency in Thailand, the process will take you almost 9 months. But in the future, we try to reduce the time to only 5 days, and let's see what we can achieve that goal. And currently, our relevant agencies are working closely to implement that cabinet decision. At the same time, we have implemented various measures and put on a lot of efforts to promote their access to basic rights and public services. For example, on access to education, stateless children are given special registration identification code, what we call the G code, so that they can enroll in any Thai public school in the same way as the Thai children. This is inconsistent with our policy to provide education for all. And on access to health care, the government has also initiated the health insurance fund, where stateless persons can receive health access to health services free of charge. And this is similar to any other Thai citizen who are covered by the Universal Health Coverage Scheme. At the local level, we are grateful to have had assistance and support from stakeholders, including the UNHCR, other international organizations, and NGOs, particularly in the conduct of outreach programs. As majority of the stateless population, they are ethnic minorities who live along the border in remote areas. So without the help of various stakeholders, NGOs, we won't be able to reach them. And we have collaboration across ministerial agencies and Thai other agencies as well, to facilitate the access of stateless population in remote area to legal status development process. This includes by providing legal consulting and support through legal clinic and and free DNA testing to stateless person, as well as operating mobile registration and providing capacity building program for frontline officers. These are important in reaching out to them, providing them with services. But with all those efforts, we still facing with some technical challenges. For example, when we delegate to the authority in the district and provincial authority to have their own decision in the process, the use of discretion by local officials, sometimes it results in varying decisions. So you cannot ensure consistency related to granting nationality and permanent residencies. Some officers they said yes, some officers they would say no. So we're trying to address that to ensure consistency. Perhaps we have to come up with internal regulations within the implementing agencies to expedite the process. And another challenge that we are facing is the resource constraints, because in order to provide services, especially in operating mobile registration in remote area, you need a lot of expertise, you need personnel, you need mechanics, the machine to support the operation. So there are a lot of resources involved, and we are trying to work with our partners to help address that issue. And with that, I would like to end by reiterating Thailand's commitment to resolving statelessness in the country, and look forward to sharing our experiences with the international community. Also look forward to learning from others and working with our stakeholders to help address the issue of statelessness. Thank you.
Thank you, Ambassador, for sharing the experiences from Thailand and how your government has tried to address statelessness. And as you pointed out, Thailand is one of the countries with the highest known population of stateless persons. And maybe that has also in one way been a way for you to be able to find a way how to solve it, because you're one of the countries actually with very solid data on the stateless population, which I think is also really one of those first building blocks when we are looking at resolving statelessness. But I think you also highlighted the commitment by your government in that already is dating back to 1992, finding solution for a number of people at that time, and also the remarkable decision last year to resolve the situation of statelessness for long-term stateless residents and their children. I also hear that your government is thinking forward in terms of how do you actually operationalize that, and thank you for sharing some of those plans for that, and also some of the challenges that you are facing. I think it will be very important for all of us to learn from how this process goes forward in Thailand, with what the things that work well and those that maybe are challenges going forward. But thank you very much for your sharing those experiences. So I'd like to then move on to the next speaker, who is Senator Mohammed Farid, who is a senator in Egypt. He's currently serving as a deputy chairman of the Committee on Human Rights and Social Solidarity. A lot of his work focuses on empowering the most vulnerable and creating opportunities for all in his country. Senator Farid, you have the floor.
Thank you very much. It's a great honor and a pleasure to be among you here today, and to be able to speak about one of the near and dear topics to my heart, when it comes to combating the statelessness and supporting the nationality rights, especially for women. So thank you very much for this opportunity. The history of the nationality rights and the gender equality in nationality, it's a bit long story. It started back in the 1950s, where Egypt had been newly independent of the British occupation, and the 1952 revolution. By that time, Egypt enacted its first nationality legislation. And by that time, we have to look at the social and political landscape. The social and political landscape, by that time, the Egyptian women didn't have the right to vote yet. And by that time, there was a very high rise of nationalism. The legislation came into that context, and it deprived women who married to a foreigner man from transferring the nationality to their children. Then, a few years after that, Egypt had joined Syria in one informing new state, the United Arab Republic. And then a new legislation had been issued to give the nationality for the citizens of this newly formed country. But a few years later, in 1961, Syria withdrew from this unity, and this union had defunct. And then there was a problem of the Egyptian women married to Syrian men, and how to confer or transfer their nationality to their children. And by that time, it maintained a lot of problem. Until in the 1970s, specifically in 1975, where a new nationality law. This nationality law had issued, and it didn't resolve much of the problems when it comes to women. It maintained the same pattern of the paternal transfer for the nationality, meaning that if a child is born to an Egyptian man, automatically get the nationality, but children born for an Egyptian woman married to a foreigner, they don't get the nationality. The same thing happens also, especially for women who are married to Palestinian nationals. They don't get the Egyptian nationality. Few years after that, there was a lot of advocacy from lawyers, from civil society, trying to push forward for a reform to allow women to transfer the nationality to their children. What happened that in 1981, another breakthrough that took place, that Egypt had signed, and joined the CEDAW, and in the CEDAW there is clearly an article that says to ensure everyone had the right to nationality and promote gender equality in laws. And we still had this, by that time, we still had this major gap. So there was a room for joining the international treaty for lawyers to be able to pursue this matter in courts of law, and also for civil society to start advocacy campaigns. By that time, also in the parliament, there were some efforts to be able to amend the legislation, but it didn't materialize to anything until early 1990s, where there was several lawsuits in front of courts to be able to amend the legislation. Luckily, the Constitutional Court back in the early 2000s said that the current constitution, the current legislation preventing women from transferring the nationality to their children is unconstitutional. This gave another step to be able to amend the legislation, but stayed until 2004. And here we're talking, started from the 1950s until 2004, with a continuous effort of advocacy from civil society, lawsuits, and parliamentary effort to be able to amend the legislation. In 2004, there was the massive breakthrough where the legislation finally amended to be able to give the women the right to transfer nationality to their children. Nonetheless, there was also a massive breakthrough by that time because it's retrospectively applied. So children who are born to an Egyptian woman married to a foreigner man, they can just apply for a request to the Ministry of Interior to get that right to nationality. This helped a lot in reducing the statelessness. This helped a lot in giving the women the right to be able to choose freely who to marry, who to continue their lives with, have a life with, and to be able to have children, and the children who has no choice at all, to their parents or to which country they are born. Now they can enjoy a nationality, which is a basic human right. Now they can enjoy education and health services and all the other services that entitled to have a nationality. So that was a massive breakthrough. 10 years later, in 2014, and by that time, Egypt had passed through 2 revolutions, and these 2 revolutions came a lot of social change, a lot of societal change, and a lot of advocacy to the women's rights, especially by the vibrant civil society. This materialized that in 2014, there was a new constitution being written to Egypt, and in Article 6 of the constitution, the right to nationality to both the children who are born to both Egyptian men or women is granted. So now it's been a constitutional right that no one can change unless, of course, some massive issue happened and changed the constitution, which is likely to happen. But now it's a constitutional right instead of being just an article in a law that might be by the change of the parliament or whatever happens. So now we have this as a constitutional right, and that was a great foundation. Moving forward to the year 2023, and another amendment took place because there was another gap about the women who obtained the Egyptian nationality. The women who obtained the Egyptian nationality until the year 2023 couldn't pass their nationality to the children. And in 2023, there was another amendment to give this right to the women. So finally, after like half a century of advocacy, half century of effort, of legislative efforts, and partnership between the civil society, the politicians, and the lawyers, we've been able to bridge most of the gaps, and now women are fully enjoying the right to confer to transfer nationality to their children in one hand, and children now enjoy the right of nationality and therefore combating the statelessness and be able to enjoy all the services that they can get or entitled to their nationality. So this is in a nutshell what happened. This could never happen in vacuum without the lawsuits in the constitutional court, without the advocacy campaigns, and without the parliamentary effort. One final thing in that manner. During these years of advocacy and pursuing to amend the law, there were real and genuine tears from the society, in some sections of the society and sometimes in the government about the security impacts of that issue, given that the state of instability that the Middle East had been, and Egypt too. In the period from the 1950s until the end of the 70s, Egypt was in wars, several wars, and this created a lot of security concerns with regard to the to this case. But still, at the end of the day, it doesn't matter if you are living in a sense of you're giving the nationality right to the children of a father Egyptian father, it should be for the Egyptian mother. But this, as might seem as plain and simple and clear to many people in that time for the society, it wasn't the case. Another important thing was about after that, when it comes to the migration waves that took place post Arab Spring and from Syria, from Sudan, and from other countries to Egypt, and this also created some genuine concerns, from the society about the state of the children going to women married from foreigners. But again, this needed a lot of advocacy effort, a lot of raising awareness effort, a lot of partnership between the civil society and the politicians and policymakers, and of course, a tactical litigation, if this is a proper term to use, to challenge the current laws in front of the court of law in one hand, and also to challenge the social norms and to be able to move forward. So with that, I finish my intervention, and I'm open to any comments or questions. Thank you very much.
Thank you very much, Senator Farid. I think it was fascinating to listen to your description about how this law was changed in Egypt. And I think we see the similar type of ingredients in other countries that have reformed their laws. And I think what you just highlighted was the importance of partnerships and really the huge role that is played by civil society organizations. That was the case in Egypt, but we've seen that also in other countries, including the involvement of women's groups and women who are affected by these discriminatory laws. So I think it was very encouraging to hear the example of Egypt. I also noted you talked about strategic litigation, and I think we could paste in the chat a new guide that has come out around strategic litigation on the right to nationality. I think that would probably have been helpful back then, but hopefully it can be something that is helpful for other countries who are still to amend their laws. So thank you very much for sharing your experience and personal engagement on these issues. So with that, I'd like to move on to our third panelist, which is Mr. Charles Muendo, who is the Deputy Director of Immigration Services of the Ministry of Interior and National Administration of the Government of Kenya. He's also the government focal point on statelessness in Kenya. So over to you, Mr. Muendo.
Thank you. Can I be heard?
You can be heard very well, thank you.
Initially, I had issues with technology, but now, if I can be heard, thank you so much for having this conference, and thank you for inviting me, and thank you the speakers that were before me. Well, I would like to speak about Kenya's experience in resolving statelessness. It is worth noting that as my previous speakers have spoken about, in Kenya, statelessness actually is historically due to the colonial era migration into Kenya and the subsequent legal gaps and the policies that excluded some ethnic communities from the getting Kenya citizenship. It's worth noting that currently we still have pockets of stateless people claiming statelessness living within Kenya. The majority were born in the country as their ancestors came to Kenya during the colonial period, mainly to provide labor. So these are from neighboring countries, especially during the colonial time, when most people came to Kenya to provide labor, and they never left. Some never acquired Kenya citizenship as they missed the 2-year registration window in the 1960s. There are others who carried the British passports. However, after the change of the British Nationality Act in 1983, their children were barred from acquiring the nationality of their parents. So as a result, these people became stateless. Now, the constitution that we had from 1963 did not have any window to actually register stateless people, because it talked about um, only Kenyans. A person born of a Kenyan parent could claim citizen, was a citizen of Kenya in the advent of independence in 1963. So the constitution only talked about the people who are born here, whose parents were born here, and were especially under the British rule, could only access citizenship if one of their parents was born here. So you see, luckily enough, 2010, we had enacted a new constitution, and in that case, that constitution brought about changes that recognized that we had stateless people amidst us, and the efforts were done to really make sure that we eradicate statelessness. However, there were gaps in the nationality law. While Article 15.2 of the Constitution of Kenya allowed stateless people to apply to be registered as citizens, Section 15.1 of the Immigration Act limits the scope of the definition of statelessness person to those who were in Kenya when it gained independence on 12th of December 1963. So you see now even the new constitution talks about only people who can claim citizenship, statelessness, are those people who have genuine claim of having been found here in 1963, 12th of December, and that excluded many people who arrived later, as well as their descendants. In addition, neither the Constitution nor the Citizenship and Immigration Act, they do not contain any legal safeguard to ensure that a child born on the territory who would otherwise be statelessness is granted nationality. So then there are also inconsistent practices towards certain population groups, including minority who cross the border populations and the descendants of historical migrants. Inconsistent practices in the vetting process to determine who is entitled to national ID cards exposed most people in various population groups to risk and statelessness. So how did Kenya began the process of ending statelessness? So in the 10 years of the I Belong campaign in 2024, Kenya made significant progress in efforts to address the statelessness situation in the country, and the notable achievements have been realized in, number one, recognition and the granting of citizenship to 1,496 members of the Makonde community in the coastal region of Kenya, and the issuance of citizenship registration certificates and Kenyan identity cards in 2016. So you see, this is the first group that benefited from the new laws, mainly the Makonde who came from Mozambique, and as I said before, in search of labor and the better opportunities. So we were able to really pull out 1,496 members of the Makonde community, and they issued them with IDs, certificate of registration as citizens, and IDs, and now from that they were able to access Kenya passports, those who really wanted to travel after they were granted that. We also granted over 10 individuals of Rwandan descent, recognized and issued with the citizenship certificates and the Kenyan identity cards on 12th of December 2020. Just recently, approximately 7,000 members of the Pemba community were recognized and confirmed as Kenyan citizens by a presidential proclamation on 28 July 2023, and issued with Kenyan identity cards, birth certificates, and those who feel like they could apply now they're eligible to apply for Kenya passports to enable them to travel, because they did not have any way to travel without passports. So the process in Kenya has mainly been through community group recognition and the registration as Kenya citizens. We do encourage the community self-registers that have played an important role of addressing the issue of lack of data on stateless populations, and was used for the verification and the registration of Shona and the Pemba communities. In fact, the same method was used to also register the Makonde community. The reason why we encouraged self-registers is because majority of these stateless people kept their culture, their traditions, and they were the ones who knew who came when, and the descendants of the people who, one way or another, unfortunately, got deceased and left their descendants behind. So we encouraged that the community register group would be a little showed the way, so that they self-registered. When that was done, we were able now to initiate the community members themselves, with the support of UNHCR and the NGO partners like Accent and Kenya Human Rights Commission, so that now the government came in to verify whether these people met the requirements of the law and the requirements of the constitution. And these community registers have been very, very helpful to us in trying to reach those people who are claimed stateless and have been here since 1963. Now, the government has now taken to progressive and active approach on the development of Rwanda and the Rundi community registers. We have also now encouraged the Rwanda and the Rundi communities that have been here with us since 1963 to also provide community registers that is done purely by them and by their elders who have a history of these communities and who can vouch for members of their communities that they indeed they are stateless and they have been here since 1963. In December 2024, the government team started the process to verify approximately 2,307 individuals who had been captured in the registers, meaning that the Rwandese who claim Rwandese national ancestry, 1,353, and the Rundi 954. This number, of course, is not conclusive, because we are still encourage them, for those who did not come out to register, to please do so, so we do not leave anyone behind. So Kenya's progressive approach. The government of Kenya remains committed to eradicating statelessness, and there is political goodwill to resolve the remaining stateless situations. As the statelessness government focal point, I continue to coordinate with UNHCR, NGO partners, and the affected populations to build and strengthen political goodwill and the commitment to the cause through regular engagement with the members of parliament and other political leaders. I must add that the luck that we have is that the political class in Kenya has been very, very encouraging to us, and they have been very cooperative. So, meaning we have not met any impediment in the political class, and that really has encouraged us to go ahead and try to eradicate statelessness in as much as we can. Because if there's no political goodwill, naturally nothing else can move. We rely on the political goodwill. And for the last few instances that we succeeded, actually the political class was on the forefront of encouraging us to go ahead and make sure that our sisters and brothers are registered. Now, the challenge that we faced was about legal reforms. And one of the pledges by the government of Kenya at the Global Refugee Forum, GRF, in December 2023 was to complete legal reforms to address and remedy statelessness by amending the Kenya Citizenship and Immigration Act of 2011 by deleting sections that really limited us from moving on. And these are 15.2, 16.2, and 17.2, because these are the sections that gave us limits so that we could not move with the speed now to address the statelessness that is left unaddressed, and to remove the time limit, because what happened was the Constitution of Kenya gave us time limit to address statelessness, but as you know, it's not that easy to move with speed, so we could not complete this process, and the time lapsed. So we are in a position now to, if that is done, to remove these limits, then we will be able to move the speed and register the rest that are now remaining. I must say that the process is ongoing, and a draft amendment bill has been completed and is awaiting publication and introduction in our parliament. If passed, then it will unlock the impasse that has existed since the lapse of the legal framework on 31st of August 2021. Let me say that we have faced challenges in this, and the main challenges that have been experienced are: number one, lack or limited data on stateless populations in support to support advocacy efforts and inform proper planning by the government. The development of the community registers is helping to address the data gap. But this is still a challenge because these community registers are not really complete, but we keep pushing as government so that we do not leave anyone behind. Challenge number two, many stateless people are invisible and they spread across the country and they're not organized, making it difficult to reach them and address their issues. There is also a perceived fear of prosecution by those who have acquired identical documents irregularly, hence a reluctance to be involved in the process. You see, when these people found themselves without documents, some of them devised ways to acquire Kenyan identity cards, which was not really lawful. And this made them fear to come forward and declare, although the government had given them amnesty, and they said that if you come forward and say your ID or your passport is not regular, if you come out and declare that, we were to give them amnesty and do not prosecute them. But not many of them believed government efforts. So there is also, as a matter of practice, the government has extended an olive branch during previous registration exercise and allowed those holding IDs to surrender them and regularize their identity documents. Some of them have done it, some of them held to these IDs because they had erased their complete, what do I call it? They erased their original origin ancestry and acquired names that were of Kenyan origin. So it became very difficult for them to come forth and be careful and trust that the Kenyan government will not prosecute them. We are still insisting that we won't go after anyone who has got these IDs. We will be able to regularize their IDs if they come forward. The last challenge is funding constraints to support the advocacy and the registration activities. This challenge impedes the exercise as it requires deployment of multi-agency teams to the ground to undertake the exercise. But I must thank the UNHCR, NGO partners, and the US PRM has been quite helpful in helping us register these people. And so with that, that is those are the steps that the Kenya government has done after the 2010 Constitution to end statelessness, and in the event that the law is amended to remove these limits, I assure that the government of Kenya is willing to make sure that we do not have stateless people in our borders, because they are disadvantaged. They cannot access services as Kenyans. They are discriminated in medical circles. They cannot access money, businesses. They can't invest. They cannot buy land. And so with that, the panelists, I end my case and thank you for listening to me. And that is how Kenya is proceeding to end statelessness. Thank you so much for listening to me, and I remain open for any clarification that may be required. I thank you so much for listening to me.
Thank you so much, Mr. Mwenda, for the intervention, and I think a really great example from Kenya in terms of how you addressed resolved statelessness for these minority groups one by one. So a lot of lessons learned that or expertise that the government of Kenya really has obtained over the years. And I think this community registration process is really quite unique. And as you explained, you know, it's not without challenges, because there needs to be a verification afterwards. And ideally, of course, that information would have been available through a more official mean, but it was a way of finding a solution in Kenya. And also for highlighting some of those challenges that you encountered in the process as well, I think was really useful. Also wanted to highlight that there's an interesting study about one of the population groups in Kenya, the Shona population, that really includes socioeconomic data on this population group before they acquired Kenyan citizenship and after. So a study done by UNHCR and the World Bank, and really showing the development and socioeconomic impact of granting of nationality. So I think that's also something worthwhile noting here. So thank you very much. And I think we'll move over to the final speaker today, Professor Macarena Rodriguez, who is a Chilean attorney who serves as the program director and director of the legal clinic at the Alberto Hurtado University School of Law. So over to you, Professor Rodriguez.
Thank you so much. Can you hear me?
Very well, thank you.
Thanks. I'm gonna share my presentation.
So yeah, there we go.
Okay, thank you so much for this invitation. It's a pleasure to be in this forum. Well, the Proyecto Nacionalidad is an initiative that works in Latin America to recognize nationality of children born in Chile and Colombia. People in mobility within the Latin America region increased more than 80% between 2010 and 2020, resulting of an unprecedented influx of refugees and migrants in the region. Many of them are...
On the screen, there's a message there. You might want to press that.
Sorry.
There's a blue...
yeah.
Yes.
That's okay.
All right, thanks.
Okay. As I mentioned, many of them are Venezuelans and live in different countries without a regular status. In 2021, Venezuela was the source of the second largest displacement of people in the world. So Chile and Colombia have a constitutional norms that recognize use solely of birthright citizenship, except for those born from parents in a country in transit or without a domicile. This exception has been understood as a barrier for the children of undocumented migrants and refugees from receiving nationality through the principle of jus soli. Both countries, taking different approaches, adopted public policies to avoid, prevent, or eliminate the statelessness of those children at birth. The Chilean constitution recognized Chilean nationality for those born in Chile, except for children born from in-transit foreigners. Since 1995, the Chilean government has used an administrative circular to establish that any person who doesn't have a residence permit in the country is considered a transit foreigner. This includes irregular migrants and asylum seekers, regardless of how long they have been in the country. Between 1995 and 2014, thousands of children born in Chile to irregular migrants or refugees were labeled as children of in-transit foreign, CTF, on their birth certificates. Those registered as CTF were denied Chilean nationality and the associated rights that come with the Chilean nationality. Many were also left statelessness. Although CTF-labeled individuals may have been eligible for the nationality of their parents through the jus sanguinis, some fell into statelessness because they were not registered in the consulates of their parents' country of origin. Several international treaty monitoring bodies, including the Committee of the Elimination of Racial Discrimination, the Committee on the Migrant Workers, and the Committee on the Elimination of Discrimination Against Women, expressed concern over the statelessness caused by the interpretation of transit foreigners and issued recommendations to Chile. Additionally, there were multiple challenges in the interpretation of the Chilean Supreme Court. The Supreme Court consistently ruled that transit foreigners should be defined as natural and obvious meaning, which means to be passing through without the intention of staying in the place. Unfortunately, the ruling of the Chilean Supreme Court are not binding precedent. Due to civil society, international organizations, and international bodies, the Chilean government recognized in 2014 through another administrative decision that this interpretation was a mistake, clarifying that transit foreigners could be those who are tourists or crew members. Therefore, the children of undocumented foreigners were eligible for the Chilean nationality. The memorandum didn't, however, address those who had already been labeled as CTF on their birth certificates. Between 2014 and 2016, multiple governmental and international organizations joined together to assist CTF-labeled individuals claim Chilean nationality since they had been born in Chile territory. This initiative, which was part of the project Chile Reconoce, resulted in a simplified process to claim individually Chilean nationality. While the initiative was partially successful, the report from the initiative acknowledged that there were over 2,000 people who still had CTF status at the end of 2024. In April 2021, Chile approved a new immigration law after 7 years of deliberation. Law defined transit foreigner as a person passing through the territory without intending to stay in it. This law simply codified the definition of a transit foreigner established in previous Chilean Supreme Court decisions. On the other hand, Colombia Constitution granted nationality based on both jus soli and jus sanguinis. But like Chile, Colombia has limited jus soli, requesting that a foreigner parent be domiciled in Colombia at the time of the birth. The Colombian government understood that foreigners without regular status don't have a domicile. Therefore, their children are not eligible for Colombian nationality. Since 2015, more than 2.8 million Venezuelan migrants have arrived in Colombia. The Colombian government estimates that 66 of these migrants and asylum seekers are in a regular situation, thus making their children ineligible for Colombian jus soli. The policy surrounding jus soli in Colombia resulted in approximately 26,000 children becoming stateless at 2019 due to an eligibility for Colombian nationality based on jus soli combined with the inaccessibility of Venezuelan citizenship. The situation was exacerbated by Venezuela cutting diplomatic ties with Colombia in 2019, resulting in the closure of Venezuelan embassies and consulates in the country. In 2019, the Colombian government, with the support of UNHCR, IOM, and UNICEF, implemented Primero la Niñez, Childhood First program that automatically granted nationality to the children of Venezuelan migrants born in Colombia after August 2015 until August 2021. It was adopted in 2019. As long as the child had been born in 2015, they could go through the process to acquire Colombian nationality through the program. Per data from December 2024, Primero la Niñez, or Childhood First, has resulted in 106,000 children obtaining Colombian nationality. When the program was first adopted, it was only intended to be in place until 2021. However, it was extended on several occasions, and now it is valid until 2025. Which are the policy results and limitations or challenges in both public policies? In Primero la Niñez, I said that more than 106,000 children have been recognized as Colombians. It is important to note that although Primero la Niñez has helped reduce statelessness, especially among the children of irregular Venezuelan immigrants or refugees, it applies exclusively to the children of Venezuelan parents, doesn't cover the children of other people in mobility. So one of the most important challenge that Primero la Niñez face is that it is not possible to access documents that prove Colombian nationality if they are outside of Colombia, which is similar to be stateless. The Nationality Project works to obtain these documents in Colombia and then prove their nationality in Chile and thus be able to obtain a residence permit for children in Chile. In the other side, Chile Reconoce, it was an important public policy, was a pioneering public policy regarding nationality in Latin America, but also have important challenges. The individual claim to be recognized as Chilean is a slow process and depends on the authority in power. There is still 2,000 children who remain as children of transit foreigners without Chilean nationality. And okay, that's my presentation. Thank you so much.
Thank you so much for the presentation and for sharing examples about how the situation of Venezuelan children have been addressed in your country. So thank you so much for that. That was very, I mean, it is one of the examples that we are looking at when it comes to protection of refugee children against statelessness, or prevention of statelessness in that context. So thank you very much. So with that, I think we've concluded on the presentations, and we have some time for comments by participants. And as we did in the previous panel, we'd like to first give the floor to member states who would like to come in at this point. I think we have Iraq. Sorry,
That's not a member state.
that's not okay. Sorry. So I will give over the word to Mexico, the speaker from Mexico.
Thank you very much. Good afternoon. My name is Omar Bielma. I'm from the Permanent Mission of Mexico here in Geneva, from the Human Rights team. I just wanted to thank very much the panelists for these insightful presentations regarding their own national contexts. So from our side, I just wanted to state that for Mexico, the right to nationality, which is interwoven with the right to identity has been part of our work in our foreign policy. For instance, we have a huge amount of consular experience on this regard, and it has also been part of our work in the Human Rights Council. In Mexico, nationality is acquired both by jus soli and jus sanguinis, and I also wanted to mention as a good practice that in 2021, Mexico reformed its constitution, specifically its Article 30. Since the reform, now Mexicans born abroad can transmit their nationality without limitation. So in practice, this means that Mexicans born abroad can transmit their nationality throughout generations. This is very important for Mexicans in the diaspora, and this also helps to prevent statelessness. I wanted to mention this also as a practice that we have developed. And just to finalize, something that we do in our work at the Human Rights Council is to make recommendations to states. We have made a lot of recommendations with regard to the prevention of statelessness to several states in their UPR reviews, and also on birth registration and identification documents. Thank you very much for your presentations, and wish you a good rest of the discussion.
Thank you very much for that. And Mexico indeed is also an active member of the Friends group here in Geneva. So thank you very much for sharing your experience there and addressing the situation of children born abroad, which can, in some cases, cause risks of statelessness. I think there's also a comment from the government of Moldova in the chat, and I don't know if you are still online. It would be very interesting if you could take the floor to share that example. If not, maybe you can get ready for coming in, but otherwise I'll give the floor to the AIM network.
Well, hello, everyone. Thank you so much. This is Hedi Mamand. I represent the Alliance of Iraqi Minors Network. For some of you to have a clear picture about Iraq, Iraq has a rich and diverse historical background and is a home to 14 ethno-religious minority groups. While the Iraqi constitution affirms equal citizenship in practice, but minorities still face structural challenges in law. So the first key issues or challenge for the minorities is the discriminatory nationality registration system that make it difficult for some minority groups, particularly Yazidis and Falikers, displaced by conflicts, to access civil documentation, including nationality papers. And the second was the statelessness risks, especially for the children born to parents who were victims of the terrorist groups of ISIS captivity, or whose religious identity is unrecognized in law. The third one is the lack of recognition of religious diversity in official documents, where citizens must often register under one of the officially recognized religions without others like Baha'is and Kakais and Jewish and Zoroastrians as the religious minority groups. So also the fourth one is the returnees and displaced minorities often struggle to obtain or renew identity documents due to the bureaucratic or politically motivated delays. So to ensure equal nationality rights, Iraq must commit to inclusive legal reforms and to eliminate administrative discriminations and officially recognize all minority identities in civil states law and practice and procedures. And thank you so much for giving me the floor to present the challenges of the Iraqi minority groups regarding the nationality and discrimination. Thank you so much.
Thank you very much for those concrete examples of challenges faced by minority groups in Iraq. And I think many of those, there's some good language and suggestions in the Human Rights Council Resolution 5316 that we are focusing on here. So I think many of those issues are addressed there. So with that, I'd like to give over the word to Umoja for Peace and Resilience. Umojan? I think it's Mr. Isaac.
Yes, can you hear me?
We can hear you, thank you.
Yeah, yes, thank you very much for the organizers of this meeting to bring us together to discuss such critical issues. And thank you very much to the previous panelists to share more about progress on statelessness in their countries. I just have one question, and my question is all towards refugees in Egypt, Thailand, and Kenya, being that you have a very high number of refugees in your country. So the question is, does your nationality law provide safeguards to prevent statelessness among children born in your countries, especially to refugees or undocumented parents? So I would like to have, maybe if you don't mind sharing progress or anything or mechanism in place to grant nationality to refugee born children. So thank you very much.
Thank you. I think that was a specific question to Egypt. I don't know, Senator, if you would like to come in on that or.
Sure. Thank you very much for that important question, actually, and thank you again for raising this issue because, one of the challenges that I guess globally we face is the case of the refugees. Egypt has a high number, not only the refugees, but refugees, migrants, and asylum seekers. For about almost, according to IOM, around all these groups together, around 9 millions. This is like 8% of the population of Egypt. This just to put things in context. Historically speaking, Egypt has always been a place welcoming refugees, just since the Holy Family and the Jesus. Right now, last year we had another progress in that manner when it comes that we passed a new legislation for the refugees that is streamline the process of registration for the refugees and the entire process of registration, offering them the support and the help they need. So this is a breakthrough. When it comes to the statelessness of the children, the nationality law doesn't apply to that. The refugee law works on the registration process and granting them the rights, while also we developed on practical terms when it comes to the policy and implementation. There are a lot of efforts done by the National Council for Motherhood and Childhood, which is the national mechanism for child protection, and they issued several guidelines, especially for children in move and how to deal with them and how to give them the protection that is needed. So to sum it up, the nationality law doesn't apply to the refugees. The nationality law apply only for the Egyptians and the parents of the men and women and the children who are having Egyptian nationality or are being naturalized and have adopted the Egyptian nationality. When it comes to the refugees, there is another legislation which is the refugees law. And one final thing that we are very, very, very proud of, the very long and historical strong relationship between Egypt and the UN refugees agency. So we're very proud of that, and a lot of great work being done here in Egypt by the UN in that team, and we commend that great work that they've been doing. Thank you very much.
Thank you very much. And just also a reminder, of course, for refugees, many of them, their primary solution for them is maybe actually to be able to return home. So it's not always that they are looking for local integration and naturalization in the country of asylum. I think for many, they still have the the desire to return home and leave that option open. So I think we'll still give the floor to March for Peace, who was trying to come in earlier, and then we had that comment from Moldova in the chat, and then after March for Peace, Nada Bala. So over to March for Peace, if you are able to speak now.
Hello, everyone. Thank you so much for this opportunity. Can you hear me?
Yes.
Okay, thank you. I have one question about the refugees and stateless also people. In obtaining the nationality from host countries due to discriminatory practices, including the threats of arbitrary deportation or detention and difficulties in amending nationality laws and registration systems or birth registration system to comply with the international law. Could the UN establish a unified international nationality verification system, that digitic international verification system for granting refugees and stateless people a international citizenship that verified by the world around? I mean, to give them or to offer them the protection, in addition to grant them the access to the basic services and provide them internationally verified international nationality to travel